everyone, I am Prashansha Srivastava presenting legal headlines of the day on behalf of Law Mantra. The wake of elevation of the senior counsel Indu Mehrotra as a judge of the apex court, while Uttarakhand High Court Chief Justice K.M. Joseph's recommendation is returned to the Supreme Court Collegium for reconsideration. Senior counsel Indra Jaising mentioned before Chief Justice Deepak Mishra at 2 p.m. on Thursday a petition on the legality of the dissection of the names recommendation by the Collegium. We agree that Ms. Mehrotra is an eminent member of the bar and we stand by her elevation, but we are concerned about the splitting up of the names, argued senior advocate Indra Jaising. Course of the hearing of the suo motu cognizance by the Supreme Court of the conduct of local lawyers in connection with the Kathua rape and murder, senior counsel Vikas Singh drew the attention of the report of the committee constituted by the BCI to inquire into the allegation. Reading therefrom, Advocate Deepika Singh Rajwat representing the victim's family before the J&K High Court and the Kathua magistrate was not restricted from appearing at any point of time. The fact that she appeared in court is depicted in the order of the High Court. The media has misreported the entire incident. The media did not report the press release issued by the High Court Association regarding resumption of work and peaceful protest for deportation of illegal immigrants. The demand for a CBI inquiry by the J&K as well as a Kathua bar association is justified. He added that the report is signed by former Chief Justice of High Court of Meghalaya Tarun Agarwal, who headed the BCI inquiry committee. Supreme Court in Delhi administration versus Vidya Gupta has held that the storing of adulterated food, even for the purpose of making some other food which is sold, is an offence. A bench of Justice S.A. Bobde and Justice L. Nageshwara Rao also held that the court, while trying an offence under the Food Adulteration Act, needs to consider the contents of the certificate of the director only, and it need not refer to the variation between the report of the public analyst and the director. Either way, whether the adulterated food is stored for sale or if such food is stored for making some other food which is sold, such storing is an offence. Where there is no reason to refer to its content of the report of PA, there is even less reason to refer to the variation between the report of the PA and the director, the bench said. 33 of the Aadhaar final hearing, Senior Counsel Rakesh Dwivedi discussed the DOT circular dated March 23, 2017, calling upon all the telecom operators to conduct an Aadhaar-based re-verification exercise of all existing prepaid and postpaid mobile connection in the light of the order dated February 6, 2017 of the Apex Court in Lok Niti Foundation versus Union of India. Justice Chandrachud remarked that the Aadhaar-based eKYC process had not been ordered by the Apex Court in the Lok Niti Foundation versus Union of India, while the DOT circular cites the aforesaid observation of the court, stating that this amounts to a direction. Dwivedi agreed, saying that the Aadhaar SIM card linkage has been recommended by the trial. We hope that someday some sense, if not better sense, will prevail on the Union of India with regards to the formulation of a realistic and meaningful national litigation policy and what it calls ease of doing business, which can, if faithfully implemented, benefit litigants across the country. A bench headed by Justice Madan B. Lokar said while dismissing a frivolous appeal filed by the Union of India imposing cost of Rs 1 lakh. The bench, also comprising of Justice Deepak Gupta, was considering the centre's appeal on a similar subject matter into previous appeals which were dismissed by the Apex Court. While dismissing one such appeal, the court had imposed Rs 1 lakh cost on the Union of India, and it was observed that the Union of India must shape up its litigation policy. The Union of India has created a huge financial liability by engaging so many lawyers for an appeal whose fate can be easily imagined on the basis of existing orders of dismissal in similar cases, the bench said. Kerala High Court has held that the government cannot reduce the pay scale of an employee upon reclassification of cooperative society, resulting in its downgrading. The court was dealing with a batch of writ petitions filed by employees, pensioners who were facing the threat of recovery of assessed payment consequent to reduction of their pay scale by the government upon downgrading of their employer society. It is open for the government fix the pay and allowances, but it cannot reduce such pay and allowances merely referring to the financial position of the society. Supreme Court has stated that mere abduction of a woman does not attract offence under Section 366 of the IPC without proof that the woman was abducted with the intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person or in order that she may be forced or seduced to illicit intercourse or knowing it to be likely that she will be forced or seduced to illicit intercourse. Further be proved that the co-accused abducted the woman with the intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person or in order that she may be forced or seduced to illicit intercourse or knowing it to be likely that she will be forced or seduced to illicit intercourse, the court said. Canara Bank versus N.G. Subbarashetty, the Supreme Court has observed that an issue of law which arises between the same parties in a consequent suit or proceeding is not res judicata if by an erroneous decision given on a statutory prohibition in the former suit or proceeding, the statutory provision is not being effective to Justice Rohitan Falli Nariman, who authored the judgment, has elaborately explained the concept of res judicata and its exception when it comes to the issue of law. The public policy contained in other statutory prohibition need not necessarily go to jurisdiction of a court which equally be given effect to as otherwise special principle of law as are fastened upon parties when special consideration relating to public policy mandate that this cannot be done, the court said. A Delhi court on Wednesday discharged Chief Minister Arvind Kejriwal and 9 others from allegation of unlawful assembly and other offences during their protest in 2012. The other discharged in the case are Banwari Lal Sharma, Dalbir Singh, Mukesh Kumar, Mohan Singh, Balbir Singh, Jagmohan Gupta, Azad Kasana, Harish Singh Rawat and Anand Singh Bhisht. The case concerned a demonstration organized by volunteers of India against corruption, against coal scam outside the Prime Minister Manmohan Singh's house. When the demonstration began, proceeding to the PM's house, the police had used tear gas and water cannons to stop them. Moved by the grim scenario in which farmers in the state are committing suicide due to bankruptcy and indebtedness, the Uttarakhand High Court has asked the state government to prepare a scheme for payment of compensation to the bereaved families, created a corpus for waiving of their loans while also passing a series of directions for the state government and the central to ensure farmers get good returns for their labor and are assured against any losses due to reasons beyond their control. Justice G.S. Patil of the Bombay High Court has directed the Pro Authority and Senior Master to institute a quota control system for assessing original court records. They were also directed to issue tokens to advocates for visiting the testamentary department and assessing original court records. These directions came after Advocate Manoj Konde, who was appearing for the petitioner in a testamentary petition, attempted to give the original court records assessed by him to an associate in Justice Patil's court. That is all for today. Thank you.